After the Council of Constance, the payment of taxes on benefices was regulated by the Church on a basis of concordats within the individual states. This led to a more limited use of the cameral obligation in the field of activity of the apostolic chamber. From the 16th century on, they appeared mainly in contracts between private individuals. I would like to stress again that these contracts came under ecclesiastical jurisdiction and were also used outside the papal state, not only when one of the parties was an ecclesiastical institution or a churchman, but also when they were concluded simply between private individuals, hence their high prevalence. Let us begin then with what may seem a paradox. Why do we speak of contracts between private individuals and in the same sentence of ecclesiastical jurisdiction? In our experience, contracts are a matter of civil law, and the Church does not deal with them. So we are talking about contracts between private individuals because they were sworn contracts. In fact, when contracts contained elements that were considered spiritual in nature, they could be transferred from civil temporal jurisdiction to ecclesiastical jurisdiction. The oath was the spiritual element that was most responsible for this transfer. In the early modern period, the use of confirmatory oaths in contracts and negotiations was widespread. According to Guy Pape, who collected the decisions of the Parliament of Grenoble, the oath was included in all contracts and had become a custom of notaries. So, what was the purpose of the sworn clauses? The first purpose was to make performance more likely, because the debtor was obligating himself with his soul, and if he did not pay, he would not only be a defaulting debtor, but also a sinner who had committed mortal sin. Second, the presence of the oath could move the contract from the jurisdiction of civil judges to the benefit of ecclesiastical ones, as I said, regardless of the subject matter of the contract. In the late doctrine of the jus commune, third, it was debated whether or not sworn contracts enjoyed the so-called executio parata. We will return to the problem of the sin later. For now, let us focus on the second and third points. As I have said, the second purpose is the transfer of the dispute to the jurisdiction of the Church. The fact that an oath to observe the contract and not to revoke it was included in the contracts allowed the transfer of the disputes to the ecclesiastical courts. Whatever the subject of the contract, the oath as res spiritualis fell within the jurisdiction of the Church. Once subject to ecclesiastical jurisdiction, debtors could incur excommunication as a consequence of their contumacy, understood as contemptus in his Latin word, that is contempt, refusal of obedience, obstinacy, also presumption. Failure to obey an order was considered an act of contumacious disobedience, and according to the rules of canon law, contumacy was the primary cause of any excommunication. For this reason, this practice was opposed by European sovereigns. Some of them regarded the extension of ecclesiastical jurisdiction to contractual matters as a usurpation of their own jurisdiction and took measures against what they considered to be a fraud. Two approaches tended to be followed. In some cases, legislation prohibited the insertion of oaths under the sanction of nullity of the contract and penalties for those who had notarized it. In other cases, ecclesiastical intervention was limited by law or by influence of the doctrine to purely spiritual elements, such as the sin of perjury. So, in Portugal, in the 15th and 16th centuries, new laws reaffirmed a medieval prohibition against any kind of confirmatory clause, thus raising doubts among jurists that it was not within the power of secular rulers to legislate in a spiritual matter. It could be considered contrary to the freedom of the church, to the libertas ecclesiae. The Spanish monarchs tried to escape this criticism and has made several legislative interventions. After the Cortes of Toledo in 1480 had forbidden laymen to bind themselves with sworn clauses, 2 years later, a pragmatic of the Catholic kings Ferdinand and Isabella made a distinction based on an old doctrine of jus commune. That is the distinction between contracts that were valid in any case without the oath, in which case the oath clause was forbidden since it was added for the only reason of weakening the royal jurisdiction, and void or invalid contracts, in which case the oath was the only source of obligation. In the second case, recourse to ecclesiastical jurisdiction did not constitute the civil fraud on which the rule was based, and the clause could therefore be legitimately inserted. It was not forbidden to swear oaths, because this would have been a violation of the freedom of the church that the Spanish monarchs wished to respect, but this could lead to the nullity of the contract. As examples of the second approach, in the German territories, especially after the Peace of Augsburg, 1555, jurisdiction over the oath was reserved to the state courts, while its spiritual relevance as a sin was judged by the consistory. In any case, with the advent of the Reformation, the civil jurisdiction of the ecclesiastical courts generally declined. In France, it was above all the jurisprudence that indicated a different way of solving the problem, reaffirming a classical principle, the principle that the oath was only an accessory to the contract, and therefore could not determine it, accessorium sequitur principale. It was left to the church to judge only the perjury caused by the possible non-fulfillment, but not the binding nature of the contract confirmed by the oath. nor its performance. A third reason for affixing oaths to contracts was that the late jus commune doctrine debated whether or not sworn contracts enjoy the so-called executio parata. That is a very rapid, quickly enforcement in the event of non-fulfillment, which did not require verification of the factual situation between the parties. The situation was not considered controversial. That is, it was assumed that the debt existed and had to be paid. Enforcement could be ordered simply by producing the instrument and summoning the party. And the possibilities of opposing enforcement by exceptions or appeals were drastically reduced by the debtor's express waiver of the right to do so. In the late Middle Ages and early modern period, the executio parata was typical of famous execution instruments as the guarentigia. We already know that the cameral obligations, despite the different formulas developed over time, always retain the character of sworn contracts and enjoyed the executio parata. It arose from the inclusion in a contract of a series of clauses, which taken as a whole constitute a formula capable of guaranteeing certain safeguards, above all, celerity of execution. In addition, there was the special guarantee of access, either jointly or severally, to an execution against the property, that is a real execution, a personal execution, that is detention in prison, and even a spiritual execution, that is excommunication. Taken together, these three forms of execution made the cameral obligation an unicum within the larger category of executive instruments of the early modern age, to which it belonged due the so-called executio parata, and uniqueness only possible for a power that also had spiritual strength. In the Papal States, the obligation in forma camere was the real cornerstone of the execution process. And the most famous jurist of the state, Gian Battista De Luca, praised it unconditionally. The cameral obligation required the debtor, just to refresh, required the debtor to obligate himself and his heirs and bind all his and his heirs' assets and property, present and future, submit himself to the jurisdiction of a specific court, which was mainly the auditor camere, consent in advance to the excommunication and personal execution up to the full settlement of the credit, renounce resisting the execution in any way, swear to observe and not revoke what is stated in the instrument. The other executive instruments used in the medieval period and early modern periods, such as the guarentigia that I mentioned, although in different ways very similar to the cameral obligation, were effective only with regard to the assets and personal freedom of the debtor. But transforming the defaulting debtors into excommunicated sinners was an additional and very powerful weapon. It signified not only striking them deep down in their faith, but also destroying their social life. The major excommunication, in fact, separated the debtor from the communion of the church and from the faithful, who were obliged to avoid him. If the debtor was a merchant, the social and commercial consequences could be very serious, but also for any believer, who, if he had died before the absolution from excommunication, could not have had a Christian funeral and been buried in consecrated ground. The enforcement procedures arising from contracts containing the cameral formula was reserved, at least in theory, to the jurisdiction of a judicial department originally belonging to the Apostolic Chamber, which eventually became independent. The Tribunal of the Auditor Camere, contemporary jurists simply wrote AC. It was an ordinary court with immense powers, which enabled it to exercise both the secular and spiritual gladius. Its prerogatives were first defined in 1485 by Innocent VIII, with the bull a prime ad devotionis. Its office was composed of a certain number of judges and a well-organized notarial structure that eventually reached up to 10 offices. At the end of the 17th century, after Innocent XII's creation of the so-called Curia Innocentiana, its seat was the Montecitorio Palace, now the seat of the Italian Chamber of Deputies. The offices of the AC were always overloaded with work, and their most profitable activity, on which they in fact depended economically, was the writing of contracts in forma camere and their enforcement. Because it was such a profitable activity, various tribunals competed with the AC for this privilege. So this is why I said the procedure was in theory reserved to this tribunal, but many courts wanted to have a jurisdiction about the cameral obligations. All in all, this obligation constituted a vexation for several reasons. The problem was, first of all, to accept in advance any form of execution, real, personal, spiritual, chosen by the creditor, without being able to raise any objection, exception, or appeal, because of the express renunciation. Then, in the spiritual involvement of the heirs, because they were not guilty of the perjury of the deceased, but were considered bound by the content of the oath. Finally, they had to renounce their own territorial judge. The second aspect of the problem was that, as time went on, the person signing the contract became less and less aware of the consequences of his act. He was not sufficiently warned that he was not only pledging all his present and future property, his personal freedom, and his soul, but also his heirs. Because if he had died before being excommunicated, the excommunication could have turned on his heirs. The broad diffusion of the formula in contracts and the speed of the procedure created an enormous amount of work that in effect fell almost entirely on the shoulders of the notaries. They often carried out the work of the judges, who in some cases did no more than sign their names on a blank sheet, which the notaries then transformed into judicial decisions. In practice, therefore, it was the notarial offices that issued warnings or executive mandates, even ecclesiastical censures, without having to turn to the judge again. The notaries used to include this formula in almost all contracts, but as it was a very long formula, they shortened it almost to the point of hiding it in the deed. Pro quibus, etc., heredes, etc., bona omnia, etc., tactis juravit, etc. In its original form, so in its extended form, the formula takes also 5 pages, and the abbreviation is only 2 lines. In taking on such a serious obligation, the contracting party was not always well informed of the responsibilities that it entailed. It was customary for notaries to abbreviate the formula of the cameral obligation to the point of rendering it incomprehensible and unrecognizable to anyone who did not already know it. If Antonio Massa in the 16th century maintained that a cameral obligation was known to all, including women and peasants, in reality and in time, the fact of taking for granted information regarding the gravity of the obligation that had been entered upon became increasingly vexatious for the debtor. From the 18th century onwards, by which time the cultural and legal climate had changed dramatically with the Enlightenment, this aspect was often denounced and lamented by lawyers. Notaries did not provide sufficient information to the parties. Lastly, the vexation consisted in the fact that the ordinary course of execution was distorted. The ordinary procedure, according to the jus commune, provided that execution began with a forced expropriation of movable property, then immovable property, and finally one could proceed to personal execution, which generally consisted of imprisonment until the debt was paid. Instead, with the cameral obligation, the debtor could be immediately excommunicated, and then, at the creditor's request, proceed against him in property and or in person, jointly or severally. In other words, the aggression against the debtor's property was residual. This was a use of excommunication reduced to the level of an injunction by a bailiff, has been said. To remedy this situation, the Council of Trent decided that excommunication should be handled carefully, and it radically changed the configuration of the cameral obligation, modifying this main feature. If excommunication previously took precedence over the other forms of enforcement, the Tridentine decrees in the 25th session on the reform had established a criterion of moderation in imposing excommunication. This is the text of the chapter 3 of the session of over Reformation. So it had established a criterion of moderation in imposing excommunication, stating that for civil cases, it could intervene only in a case of difficulty of foreclosure or personal enforcement. Therefore, it was now the imposing of excommunication that came after the execution against property and freedom. It was a response to the abuses that were being carried out on a daily basis but also an attempt by the church not to be in opposition to the policies of the states. In 1570, the Constitution Inter illa of Pius V adopted the decree of the Council of Trent. And beginning with this disposition, the cameral obligation entered the second phase of its history, the modern phase. In this new phase, the cameral obligation was only apparently less vexatious. Of course, the debtor was not immediately excommunicated, but the procedure against him was even easier and quicker, and his heirs were even more involved. So, let's return to our Michelangelo. Now, we can better understand why he was so concerned. In a contract signed before the Council of Trent, excommunication was the first means of enforcement. But he was not alone in worrying. The splendid Renaissance and Baroque Rome was built by concluded contracts with artists and craftsmen, which contained obligations in forma camere. And, in fact, it was also used outside Rome for works of art commissioned by the church. In some jurisdictions, cameral obligations were forbidden outside ecclesiastical jurisdiction. This was the case, for example, of the Kingdom of Naples, Spain, Florence, Milan, Genoa, the Duchy of Savoy, and so on. But as in the case of Michelangelo's Florentine contract in Florence, the forma camere was forbidden. It was permitted and used when a commissioner of the work of art was the church. Very often, art historians add to their books appendices of documents that include the contracts of the artists they are studying. They are not aware of it, but if you looked at these appendices carefully, you would see dozens and dozens of contracts in forma camere. In fact, in the artistic field, the extreme importance of this kind of obligation in regulating legal relations, both between private individuals and between public and private patrons, emerges with great clarity. Just to give a few examples based on contracts that are known to us, Caravaggio committed himself under the cameral obligation for artworks to be executed in the churches of St. Louis of the French. This is the Cottarelli Chapel. And in Santa Maria del Popolo. This is the splendid Cerasi Chapel. Nicolas Cordier for a bronze statue of Henry IV of France in the Basilica of St. John Lateran, Rubens for high altar piece of the Chiesa Nuova, for the Sapienza Dome, which was feared to be too heavy, Francesco Borromini gave a guarantee by committing himself with a cameral obligation. Io infrascritto inerendo all'obbligo che per ragione comune hanno gli architetti di mantenere per lo spazio di anni 15, eccetera, obbligo me, eredi et beni in forma camere apostolice. Finally, in the church where I was married, Sant'Andrea al Celio, there is a splendid fresco by Guido Reni of the martyrdom of St. Andrew, also commissioned by contract in forma camere. These are just a few examples of the many works commissioned through obligatio cameralis that I have seen. in 2018, I wrote a book on cameral obligation, the title of which was Espropriare e Scomunicare, expropriating and excommunicating. At the time, of course, I was aware of how widespread it was, but not of the huge impact it had on art contracts. The following year, I was contacted by a team from the Center for Advanced Study and the Visual Arts at the National Gallery of Arts in Washington, D.C., who were working on the documents of the Accademia di San Luca. This is the website. The name of their project is the History of Accademia di San Luca, 1590 to 1635, documents from the Archivio di Stato di Roma. This was the start of a collaboration that continues to this day. Named after the patron saints of artists, the Accademia di San Luca still exists. It was founded in the second half of the 16th century to bring together Roman artists, initially only painters and sculptors. Its legal documents are preserved in the state archives in Rome, and the American team is involved in transcribing and digitizing these documents. These documents, in my opinion, testify to the frequency with which the cameral obligation was used in the legal relationships that founded the activity of Roman artists. Even the Academy's statutes stipulated that even any imprestanza, that is a loan or commodate, had to be formalized with the cameral obligation. Many types of obligations were assumed in that form: rents, warranties, censuses, etc. Artists also undertook to pay in forma camere the tax on evaluations. That is a tax consisting of the payment to the Academy of the 2% of the estimated value of each work. Even the deputies of the Congregation of Painters undertook in forma camere to celebrate intercessory masses in the Church of St. Luke. I would like to share with you some examples from the project website. These are very short texts that could have been contained in a slide, but a lot of them are very longer. The notarial document is transcribed with all its references of date, time, notary, and is also reproduced digitally. This is only an image, but on the web page it can be enlarged and read directly. So this is the first example. You can see in yellow the summary, and then the transcription. In yellow is the formula cameralis. Tommaso Laureti delivered the chapter books to the vice director of the Company of San Luca. The vice director had to sign them and return them to the company, but he promised to do so with a cameral obligation. So you can see in yellow pro quibus, etc., se, etc., bona, etc., in forma camere, etc. So the same two lines we have already seen. No. Another one, Avanzino Nucci undertakes to donate to the Accademia di San Luca painting for the altar as an alms, that is an elemosina. which he undertakes in forma camere. So it was just a donation, but he had to undertake it in forma camere. Now, our Guido Reni, again. In this document, Guido Reni promised to pay the Academy 2 scudi for every 100 scudi received for work done in the Apostolic Palace. The evaluation of the work was not done at the moment. In the Apostolic Palace, he decorated 2 rooms. The Sala delle Nozze Aldobrandine and the Sala delle Dame. Here, we have a picture of the room's vault of the Sala delle Dame, now part of the Vatican Museum. So, to conclude, the life of the cameral obligation was long. It lasted until the beginning of the 19th century, when Pius VII's Codes of Civil Procedure of 1817 abolished the effects of the clause for the future. This provision, although confirmed by his successors, was not included in the rules of procedure in civil proceedings, that is, the Regolamento di procedura nei giudizi civili of 1834, which specifically abolished the earlier codes. For this reason, still for some time after its promulgation, cases deriving from contracts stipulated with the cameral formula continued to be processed until 1843, when it was finally declared over. Thank you.
Thank you very much, Antonia, for this very interesting speech. For legal historians, it offers some thought-provoking and notes that I would have a few questions for you, maybe, but I would like to open the floor if any of the students and also my colleagues, legal historians here present. It's one of the topics that we teach, we have in our program of legal history, the vested pacts, los pactos vestidos, and actually, Fernando Martinez, also professor of legal history, is the author of this part of our book that we wrote about it. So legal historians, we have a few questions, but I'd like to open the floor for you first. If you have any questions, as Liliana.
What mentioned that excommunication is the worst punishment to prevent the social death of the person. But my question is, are there any punishments for people who contract with people who were excommunicated, people who were supposed to be socially invisible, or were they free to, let's say, ignore the excommunicated status of the people they were contracting?
Sorry, I didn't understand.
If a person was excommunicated,
yes,
were others prohibited from contracting with them afterwards?
Yes.
Were there punishments for these people, and were they also?
No, it was not possible to contract. They must be avoided.
It's not possible to have a contract with a heretic.
But if the contractors were with other religions, like Protestants or maybe Jewish people.
In papal states.
For example, Spanish have a large population of Jewish people. I believe the jurisdiction of the church was an interest.
Okay. There are 2 different problems. Inside the papal states, of course, there is no Protestantism, and all the people lives under one religion. So if you are excommunicated in the papal state, there is no chance to make anything. If you are excommunicated outside the papal states, well, of course, it's not the same thing, because if you lived with Protestant people is not so important, the excommunication, but if you are excommunicated, you are supposed to be Catholic. And well, the problem is inside the ecclesiastical jurisdiction. Outside, you can do what you want. So it is a problem of social life. So if you live between the Muslims, that's no problem. But it is difficult to think that this kind of penalty would be given to someone who lives between the Muslims. No, so theoretically, you're right. Practically, there are a lot of things before to say that someone had a penalty or not. So in France, for example, there was a widespread use of the excommunication for debt. And it was a very big problem for the poor people who were only excommunicated, and they discovered it in the church on Sunday when the priest reads the list of the excommunicated people. And this is, of course, in such a context, this is a problem, of course. If you live everywhere under other religion, it is different. I understand it.
I'm not a legal historian, but I suppose the official, the reading was the policy. So, okay, there were other people, but then, I mean, there might be a contract between them, but it was almost meaningless. No penalty could be enforced officially.
He is isolated. He is isolated.
It would be isolated. It wouldn't have nothing to do with this.
Because if you have something to do with someone who is excommunicated, who risk to be excommunicated as well. So also the family can be excommunicated if they don't abandon him to his life. There are the letters of aggravation and re-aggravation for a family, for example. So it is an ugly situation. Yeah.
So the contracts were written in Latin.
Yes.
So that means that
Or later in Italian.
while they were written in Latin, that means that all these and the peasant or speaking or could read Latin, or perhaps some of them would not. It was not a dead language.
No. Yeah, no, it was the legal language, but there are a lot of contracts which are written, I don't know,
In Italian,
in Italian with the part, no, these are all in Latin. The part is in Latin.
so they should know, otherwise they would need a translator.
No, but or they knew the clause, or they didn't know it. But it was impossible to discover it in the contract because it was only 2 lines. It was 2. Yes, but no, a lot of contracts are in Italian, in the vulgar language. Also, some of Michelangelo, for example. The problem is not the language of the contract, because Michelangelo needed to know what he had to do. So the statutes, for example, yes. But the clause with the cameral obligation was always in Latin.
It's more probable that they need a translation for the Italian contract than for the Latin ones, because all
I know that everything was taught in Latin at the university, but there were Simple people with perhaps artists too, who were considered as workers and not as artists all of them. So what about them?
The majority were in Latin.
We have another question, no? So no, it's interesting to see that they were all painting so beautifully because they were afraid of going to hell. They did not, it would fall under the obligato cameralis. So maybe my question just to hear more from you. Italo Birocchi and all the development of the vested contract as a doctrinal, the doctrine of the jurists of the jus commune, how they built this idea progressively. So the question would be the role of canon law in this.
It is controversial.
Yeah. So and the other one would be also it's already in Durantius, Guillaume Durand, as you mentioned. So is there a strong notary basis in the origins of the obligato cameralis, or it's more a doctrinal, or is there a strong court basis, or is it really a more doctrinal construction? So no, it's a difficult question.
I begin from the second. Okay. At the time of Guillaume Durand, it was a custom of the Roman Curia, but it was something only having to do with the apostolic chamber. So every loan, for example, with the apostolic chamber had this form, but it was a curial contract. It was not used by private individuals. And during the Avignone period, it is the same. So we have documents about the different formulas in use, but it was something a little bit different because it was something every time about ecclesiastical benefices, taxes, so fiscal causes with the apostolic chamber. It is from the 16th century onward that it has a widespread use between privates. So it has like two different lives. The second question is more difficult because, so in theory, if we speak about the nature of the contract, nudus pactus, and so on, we know that canon law had a very clear position about, for example, the actionability of the nudus pactus, of the naked pact. And in canon law, the consent was the base for every contract. This is not a problem of substantial canon law, private law. Here it is a problem of executive procedures. So in theory, they spoke about the consent and so on. In practice, they use this kind of contracts where the debtor was really oppressed and vexed because he couldn't express his consent for a lot of things. So he could also say, okay, I agree that I will realize 14 statues and you will give me this money. But he couldn't ask for different consequences from the consequences already in the clauses. So no exceptions, no appeal, no anything.
Yes.
Can you please speak? I only heard 50 years, but I'm old now. So, mm. Okay, he was desperate because he was old and he didn't remember that the contract was changed and there was no cameral obligation anymore. So he was old, almost like me. And so this is the reason why. He could remember what happened 50 years before, but he couldn't remember then the heirs of the Pope decided to nullify the cameral obligation in the contract. So it was a problem of memory.
Any more remarks? No one. Okay, so we thank Antonia very much for this very nice speech, and in a few minutes, not yet ready, but in a few minutes we can go downstairs for the coffee in the same place as the other day, but we have to wait for a few minutes. They are still finishing to prepare it. Okay, so you are welcome and thank you, and we are sorry about this. With a few assistants are still watching, and we had an issue, a technical issue today, but yeah, we hope next time. So thank you.
You're welcome.